Good afternoon, Mr. Raubal. So you're going to be asked questions, maybe on first on claimant's side.
EuroGas does not plan on asking Mr. Raubal any direct questions. I do not know about Belmont.
Nor does Belmont.
Then cross-examination. Sorry, you have a declaration in front of you. Can you read it aloud, please?
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you.
Thank you, Mr. Chairman. Mr. Raubal, my name is David Alexander. I represent the Slovak Republic, and I'm going to have the privilege of asking you some questions on cross-examination. It's important that you understand my questions. If you don't, please let me know that. Fair enough?
Correct.
Mr. Raubal, you have before you your witness statement, and do you affirm the truthfulness of that statement?
That's correct.
And you filed only a single witness statement in this proceeding, is that right?
That's correct.
Have you been following these proceedings closely?
I did.
And you read the documents before they're filed and comment on them, I assume?
That's correct.
Now, you, of course, presumably had an opportunity to read the various witness statements filed by witnesses submitted by the Slovak Republic, have you not?
That's correct.
So you've read Mr. Heidecker's witness statement?
Yes.
And Mr. Dorfner's witness statement?
Yes.
And Mr. Heidecker? Let's see, one more. Chorite, thank you. Is that correct?
Correct.
All right. Did you consider submitting a further witness statement after reading those documents?
I would have to discuss this with my lawyers.
Well, I'm not interested in the content of any particular conversation you had with your lawyers, but did it occur to you as the representative of one of the claimants in this proceeding that there might be information in those statements that you'd like to respond to?
Yes, for sure.
But you elected not to do that?
Not yet.
And by that, am I to infer that you are going to share with us now, for the first time, what your responses are to those witness statements? Is that right?
That's right.
All right. Mr. Chairman, we'll note our objection without argument.
May we respond? First, a question. You're not interested in the content, but it's a question of strategy. Responded, I would want to discuss that with my lawyers. So it's a privileged information. And we didn't ask Mr. Raubal any questions on direct, so he's happy to respond to your cross-examination.
I don't think it's appropriate to argue in front of the witness, but I just want to note for the record our concern about this approach. Thank you. I'm going to be working through your witness statement for a fair portion here of the proceedings, and you, of course, have that before you. I'm also going to bring to your attention some testimony from other witnesses that we've just identified and perhaps others. So our colleague is seated to your left, and we'll have those documents and may also help you find your way through some exhibits as they become available. Now, in the opening pages of your witness statement, you describe your history in the mining industry with a variety of companies and in a variety of jurisdictions. Correct?
That's correct.
Had you ever had any experience with Dorfner before?
No.
Gebruder Dorfner?
I met them during the acquisition period of the Rosmin project.
That was the first time you'd had any dealings with them?
Correct.
What about Tyson and any of its affiliates? Have you ever met them before?
Yes.
And in what context?
We had a joint venture in Brazil together with Anglo-American, South African gold producer.
And when was that project?
In the 80s, early 80s.
And did that project result in any disputes between Tyson and you or any company you were involved with?
No,
So you had a ordinary business relationship with them?
correct.
Now, did you have occasion to review your memorial before it was filed in this proceeding?
I did.
All right. And you, of course, also reviewed Mr., let's see, it would have been, I'll have to find that in a moment, but, there it is, Mr. Rozloznik's witness statement, which you'd earlier indicated, I believe.
That's correct.
Both his witness statement, and if you want me to call this up for you, I can do it. I can get it before you, but I don't think it's really going to be very controversial. He had described them as world-renowned or world leaders in the mining industry. Did you share that view?
I do.
And what was the basis for your view that both of these companies had world stature?
Well, Tyson is known as a world giant in steel manufacturing. Excuse me. Dorfner is a small company, small German refining company.
And what was your understanding of Tyson's work in the mining industry?
There are two Tysons. Tyson Schachtbau, the one we are dealing here with, and Tyson Steel Company. The steel company is indirectly related to Schachtbau. Schachtbau belongs to the Tyson family. Both have good reputation, very good reputation.
And what in particular is Tyson Schachtbau, is that it? Their specialty as it relates to mining?
Building shafts and preparing a mine for production.
Now, both of these companies were already involved in the Gamerska Paloma project when you came to that project in 1997, were they not?
Correct.
And how did you happen to come to the project in 97?
Mr. Chori had asked me because he didn't have the necessary funding to maintain his share position in Rosmin, or in the joint venture, and he was afraid, excuse me, distinct members, and he was afraid that they might simply dilute him out of the project.
So did Mr. Chore contact you initially?
Initially, I was contacted by Dr. Terscher, a minister or state secretary of the Ministry of Environment of the Slovak Republic, and he arranged a meeting between myself, Mr. Agiagos, and Mr. Chori in Europe, but I had met Mr. Terscher in Canada while he was there on a holiday. I had met him before in the early 90s because Bill Agiagos and myself, we were looking for mining properties in the Slovak Republic which we could get involved with.
And did Dr. Terzer advise you as well that Mr. Chore's company, with which he was involved, Rima Moran, was looking for a strong financial partner?
Of course, because Mr. Chori was just about to be dropped out as a shareholder of the joint venture with the German companies.
And how did you acquire that information that he was about to be dropped out?
Mr. Chori told me himself, and also Mr. Terscher told me.
Did you verify that with Dorfner or Tyson at any time?
Of course. We had meetings with Dorfner, with Tyson at that time, not with Dorfner. I met Dorfner later on, and they confirmed that unless Rima Muran would pay up, they would be dropped out as shareholder.
And were these meetings in approximately 1997?
Yes, I think it was 1997.
Now, you also met with others in connection with the project, didn't you?
If you help me, I would appreciate
I
it.
will. That's fair. I've had the benefit of looking at your witness statement a lot lately, so I will try to do that. For example, you met with Hansa Geomin,
Yes.
and who were they in the project?
Well, they were not a participant in the project. They were a mining consulting company, or rather a mining consulting company, I think is the right word. And they were asked by a German subsidiary of the German Republic's main bank, to confirm certain data which Dorfner and which Tyson had prepared in a pre-feasibility study, and they confirmed this.
And was the name of that institution, for short, DEG?
Correct?
Do they have any relationship to Deutsche Bank?
No. They are the branch of the German Republic. They control all the investments for the German Republic.
And you were aware, of course, that a feasibility study had been done?
I was aware at that time a pre-feasibility study was done.
And who prepared that?
I believe it was prepared by Dorfner and Tyson.
And what was your understanding of why DEG was involving Hansa Geomin? What was DEG's role at the time?
Dorfner and Tyson had asked DEG to fund this project.
What was the status of that request?
They were requesting 60 million Deutschmarks at that time, which is at today's conversion rate roughly 30 million euros. And they had asked, DEG had asked Hansa Geomin to confirm the pre-feasibility study.
So, was it your understanding that the 30 million euro request was based upon a budget for what it would require to bring the mine to production? Is that your understanding?
My understanding was that 60 million Deutschmarks would have provided the first portion of the project.
Right. And there were two other substantial portions as the project evolved, which actually increased the projected capital costs, were there not?
I don't recall, Mr.
Do you recall that the second pope planned for opening and something, I can't remember what the acronym goes for. Forgive me for that. I'm learning a lot, but I can't remember all this, so work with me if you will. The second pope actually contemplated a different horizontal shaft into the deposit area. Does that ring any bells with you?
Are you referring to the first POP, they call it?
I was actually referring to the second one.
Second one, but done by Rosmin or done
Yes.
by?
Yes. Tell you what, we can come back to that later. Let me come at this
I
a
don't
different
recall
way.
quite
If I can
frankly.
make a suggestion on those, these things happened so long ago, and you're talking about
That's
different
fair.
documents, if you could put them in front of him when you
That's
ask.
fair. I want to start out with just understanding actually what he does recall, but I think, I really, if you can't answer without seeing the document, understand. As you sit here today, we had the 60 million Deutschmark request to DEG, roughly 30 million euros. Were there changes to the mine plan that actually increased that cost during the course of the first 3 or 4 years?
I don't think so.
Okay. Did that include the processing plant?
No? You talk about the flotation?
Yes.
No, I don't think so. I give you the reason. The current operator, Eurotalc, which is owned by Schmid Industry Holding in Austria, has been negotiating with us for the last 2-3 years to purchase their interest in the mine for their investment, which is approximately 30 million euros. And we had made and have made arrangements through a London investment house to purchase this project. And a year ago, unfortunately, Schmid Industry Holding declined to provide us with sufficient due diligence and then suddenly stopped the negotiations. So I assume, because their price was 25 to 30 million euros, that this is roughly the figure we are talking about.
All right. Now, the mine at the stage in 1997, when you came in with the feasibility study and the Hansa Geomin work having been done, the borehole drilling had been limited to surface drilling. Is that correct?
Correct.
And then Roseman came to the view that some additional drilling would be helpful to further understand the deposit. Is that fair?
It was not helpful, it was necessary.
And was consideration also given to the possibility of further assessment after the deposit had been opened by underground drilling?
Can you repeat your question, please?
Yes. Was consideration also being given in the mine plan to the possibility of further assessment of the deposit by deployment of underground drilling after the deposit had been opened?
Well, in order to delineate all reserves, you have to do underground drilling. You have to drill from the level which you, I call it the tunnel or the shaft, in order to get to the true picture of the ore body.
All right.
Otherwise, it doesn't makes any sense.
So it was always contemplated then that there would be underground drilling as the mine was opened to get, as you say, to the true picture of the deposit.
That's normal practice in mining.
Right. Do you know if the capital estimates that you were considering at the time included that additional underground drilling?
Probably.
You would expect that.
Well, I'm coming back to the Schmid proposal because he has done underground drilling, extensive underground drilling. And if he wants $30 million, I assume that these expenditures are included in it.
Right. Now, at the time you first came to the project, were there any proven reserves in the SEC sense?
SEC sense means blocked out from 3 sides? No.
And prior to 2000, were there any proven reserves from the SEC sense that you felt it was appropriate?
Sorry, there was a noise.
Sure.
Prior to?
Prior to 2000, the year 2000, were there any proven reserves in the SEC sense of the deposit?
Well, Rosmin did drilling, as I said before, and this gave what we would call in North America a semi-proven deposit, semi-proven figure.
You're familiar with the Crookes standards. You have to speak for them to record it.
Yes.
Yeah. And the phrase you just used, could you give me that again? When I asked if there were any proven standards, what did you say?
Semi-proven standards.
Semi-proven.
Semi-proven reserves.
Yeah.
I would consider these semi-proven reserves.
Yeah. And that's a concept not recognized in the Kirkshire standards, is it?
It's a concept recognized in the Canadian mining
Right,
standard.
but not in the Kirkshire standards. Is that right?
Correct.
And it's not a concept recognized in the SEC world, is it?
Correct.
And you were a public company having to report on Securities and Exchange Commission quarterly and annual filings, correct?
Correct.
And it is true that from 1997 through 2004, EuroGas never reported that it established proven reserves in any SEC report, had it?
Correct.
Nor had it reported that it had established any semi-proven standards, because you recognized, or your counsel did, that that was not a legitimate way to report in the Securities and Exchange world.
Well, we didn't have the necessity to report this because it affected the subsidiary Rosmin.
There came a point in time, though, of course, when you consolidated the operations and financial affairs of Rosmin into EuroGas's financial statements, right?
Right.
And you reported on the mineral resources that Rosmin held certainly from that time forward.
That's right. But there's still no necessity for us to report this because it's a subsidiary.
Would you agree that if quote-unquote semi-proven standards had ever been discovered, the market might have been interested in that?
Semi-proven reserves mean nothing. You need proven reserves, blocked out 3 sites. If you don't have them, you don't go into production.
Thank you. Now, during the period prior to the reassignment of the excavation area in early 2005, at any time between 1997 and 2005, did you ever get to proven reserves in the deposit?
No.
Now, would you agree, Mr. Robal, that the Gamerska Paloma project and that site was challenging technically?
That may be the case, but it also had tremendous potential to be the largest deposit in the world.
And would you agree that it also proved to be very challenging financially?
Any project of this kind is financially a big hurdle.
Well, let me be clear. You went into the project on the assumption that you could provide the financial strength that you promised to Mr. Chore. Fair enough?
That's correct.
And you later continued in the project with confidence that you could provide the financial strength that you promised to Belmont when in March of 2001, you promised to have it in commercial production within 1 year, correct?
Correct.
But in fact, you were able to achieve neither of those, were you?
I may have achieved it if Mr. Chore wouldn't have played a dirty game.
Well, we'll come back to that at some length. But the fact is that during the period where you had problems with Mr. Chore, EuroGas was the majority stockholder in Rima Moran.
Correct.
So Mr. Chore worked for Rima Moran, correct?
Yes.
So to come back to my earlier question, the fact is that you were never able to achieve the commercial production within 1 year that you promised to Belmont. I think that's a yes or no question. You can explain it if you want, but I think it calls for a yes or no answer.
It is yes. But I
Yet-
just wanted to give you the explanation.
Please go ahead.
I had at that time a firm commitment, excuse me, a firm commitment from one of the largest talc producers in the world, Mondo Minerals, and also from Rio Tinto, from their French subsidiary. They had made numerous visits to the mine, and they were prepared to enter into a joint venture with us. So I didn't have this concern of raising money. I knew I would end up in a future joint venture with them, except they were very unhappy with Mr. Chori. They didn't like Mr. Chori as an operator in there.
So at that point in time, and what point in time was this?
That was over a period of 2 or 3 years, I would say.
Is there a reason you didn't mention that in your witness statement?
No, there's no reason.
You knew that concerns about capital adequacy were central to this case, did you not?
Of course, any mining project is very sensitive as far as financially is concerned.
But you didn't say a word about Mondo Minerals, Rio Tinto, or the other company you mentioned in your witness statement.
Well, there was no need to do that.
And you haven't put into the record, have you, any documents showing that you had finalized financing or investment arrangements with any of those companies?
We may not have submitted the documentation, but we have that documentation on file.
And even after the Slovak Republic's counter memorial called into question whether you would ever be able to bring the project to commercial production as you had promised to Belmont, you elected not to submit that information, didn't you, Mr. Robol?
I elected to give you the information when you questioned me.
But my question was, you elected not to put it into the record, the documents you claim you have.
I did not elect it. I repeat my answer. I elected to answer the questions to you and give you the picture.
So that was a conscious choice on your part, not to put it in the record, but instead to handle it in cross-examination.
Correct. I may add, members of the tribunal, that Dr. Roslosnik will confirm what I said. We had numerous visits from many senior mining companies which were interested in either a joint venture or even also an outright sale over that period of time which I just described.
Mr. Robol, the fact is, though, that although you had lots of discussions, which you now claim, you never brought any new cash or equity to the project from these companies, did you, sir?
Well, I made the remark before, Mr. Chori had caused these problems.
Could you please first, though, answer my question?
What was your question again, please?
My question is, Mr. Robol, the fact is that although you had what you claim were lots of discussions, you never brought any new cash or equity to the project from these companies, did you, sir?
I did not bring the equity to place this mine into production, that's correct.
And all of these companies that you claim to have talked to, for which you elected not to put any documents into the record, none of them contributed any cash to the project, did they?
No.
And you now say that it was because Chore was the problem, right?
Chori was a problem to those companies. They didn't want to work with him.
And did it ever occur to you that as the majority shareholder of Rima Moran, it was surely within your power to make a change?
There is documentation on file, I believe, about a big quarrel which I had with Mr. Chori when he was voting at an annual meeting or a document or an important meeting. He was voting against the majority shareholders. In other words, our intention to do certain things, and I protested against this.
But you did have majority control of the company.
We did, yes.
So the fact that Mr. Chora was voting against you surely didn't stop you from making a change if you believed it was necessary as the majority owner.
That's correct. We made the change.
And you made the change to eventually involve Cigarette, is that right?
No, we made the change to take Rima Moran out of Rosmin by converting our, excuse me, by converting our advances to Rima Moran into an equity position of Rosmin. This is what crystallized then in the 57% shareholding in Rosmin.
And did you, in fact, have the votes to replace Chore as the majority shareholder in Rima Moran long before you took those steps? You did have that power, didn't
Yeah,
you?
but it wasn't long before. This, what I described, happened over a period of 2 years. We were so disenchanted with Mr. Chori that we decided to exchange our capital expenditures in Rima Moran into an equity, into acquiring his Rima Moran's equity interest in Rosmin.
When did the problems with Chore begin? What year?
Mr. Alexander, this is 25 years ago. I don't know. I think it might have been 1 year before, 1 year after we got involved, 2 years. It's all within a very, very short period of time. We're not talking about years, we talk about 2 years maximum.
Members of the tribunal, I'd like to show the witness a document and distribute that document. It's not one that's in the open binder yet, so I'll ask my colleague to distribute that if I may. Give you a minute to look at it. Let me know when you're ready, Mr. Roboff. Mr. Robal, do you know the company Riga? R-E-G-A?
No.
You ever heard of them?
No.
From your experience in the mining industry, what do you understand this document to be?
It's a complaint by Mr. Chori, which in my opinion was totally unwarranted, but Dr. Roslosnik can give you probably more details about it because I was not involved in the day-to-day operations.
The fact is that there were inspection reports performed concerning Mr. Chori's work. Isn't that true?
I don't remember.
But Mr. Loznick would have had responsibility for and would know about that?
Correct.
Is there any documentation that you advised the mining office of your claimed problems with Mr. Chore before the works were suspended?
I was not involved in the day-to-day operations, Mr. Alexander. But I'm sure that Dr. Roslosnik will be able to give you an answer to that.
Did you grant any of Mr. Chore's requests for additional amendments to the contract?
I don't remember.
Did you agree to increase his compensation at any time?
I don't recall. Unless you have a document to show me, to refresh my memory, I don't recall.
I think we'll work with Dr. Loznick on that, given what you've said about your lack of knowledge.
Right.
Now, at the time you entered into an agreement, well, let's back up. Let's back up in time. Did the fact that Tyson and Dorfner had already spent substantial time and developed a feasibility study and had gotten Hens of Geomin involved, did that give you some comfort in considering investment into the project?
Of course.
And why was that?
Well, because these guys are responsible, these companies are responsible companies.
And did you believe their participation would be valuable in attempting to attract further investment?
No.
Help me understand this, Mr. Robald. As a layman, unfamiliar with the industry, if you've got world-renowned companies involved in a project, I would think that a lender or a potential farm-out participant might take some comfort from that.
The problem has been that Thyssen-Schachtbau was in financial problems, which led to them approaching us and Belmont to sell their interest in the project. Dorfner was only a small company in relationship to Thyssen-Schachtbau. They are more or less a medium-sized German refining company and producing soapstone for industrial purposes. So the key element here was that Thyssen-Schachtbau had internal problems and came to us and offered us to purchase this interest. In the beginning, they wanted 10 million Deutschmarks for their interest, and then later on, Belmont successfully negotiated a far substantially lower price.
Is there a reason you didn't say anything about that in your witness statement?
Well, Mr. Alexander, with due respect, I cannot go into all the details. I'm giving you the general guidelines, and you can ask me questions and I fill you in with the answers.
So your view at the time you were preparing your witness statement was that was just too general?
That was not my view. That was the fact. Thyssen was in financial trouble and they wanted to sell their interest. Dorfner was not prepared to go alone in this project because they are not an engineering company. They are not a company which is building shafts. They don't have, maybe they have the financial means to do that, but in the end they cannot do this alone. So they both decided to get out of the project, and they did. They wanted, in the beginning they wanted substantially more money in the 10 million Deutschmarks bracket, and then later on Belmont was successful in buying it for some, I forgot the number, 3.2 million Canadian equivalent.
And would you agree with me, Mr. Robal, that you did not put into the record any evidence that supports your assertion today for the first time that Tyson Shuckbow was in financial trouble?
Well, the whole world knew that. You can go to the records and see on the internet they were in serious problems. The whole world knew this.
So the answer is you decided not to put it into the record because the whole world knew it.
Well, it's public knowledge, so why should I put it into my statement?
Now, you of course are aware of the witness statements filed by Mr. Heidecker, correct?
Yes.
And he described, I'm sorry, by Mr. Dorfner, he described different concerns. Do you agree?
If you give me again Mr. Dorfner's
Certainly. Let's show him.
statement to refresh my memory, yes,
Of
then I
course.
will give you the answer.
Mr. Dorfner first. Does the tribunal have,
These are the same
All right,
witness
great.
bundles.
great,
It's the tab number 4 from the witness bundle that you received early in the morning.
I'm going to ask you about paragraphs 10 and 11, 12.
Okay.
First of all, you would agree that there's no suggestion in Mr. Dorfner's statement that they were having financial problems which caused them to leave the project.
I didn't say that. I said Tyson had financial problems.
All right? So we'll come to Mr. Heidecker's statement in a moment on that. But before we do that, so we don't do
But
any
let me
more-
make a remark after I refresh my memory. Paragraph
Wait a second, Mr. Robal. I'll ask you a question. You can answer it if you want to explain it, that's fine. But you don't get to just make remarks.
I apologize.
Mr. Robal, would you agree with Mr. Dorfner's statement that the project was financially very demanding? I think that's non-controversial, right?
I said that before.
All right. And did you also agree with his statement that Mr. Chore had approached the Tyson affiliate, OSTU, and Gebruder Dorfner with an idea to secure financing for the project by involving EuroGas GmbH? Were you aware of that?
It was me who gave him personally money in order not to lose his interest in the mine, so I agree.
So you authorized Mr. Chore to make that proposal to the shareholders of Rosemont.
Yes,
And you became aware that they clearly refused to permit that.
who refused?
Dorfner and Tyson.
They did not refuse it. They accepted the proposal. Otherwise, we wouldn't have been involved in the project.
Well, I think you're actually mistaken about that, Mr. Robal. Let me explain to you why, by asking you another question. Do you dispute the statement that cooperation was not acceptable for OSTU and Gebruder Dorfner Do you dispute that?
Yes. That's wrong. Why
And when
would
you
they
went-
have us, why would these two companies have us accepted as a partner if Mr. Dorfner comes to this opinion here? That's wrong.
Right, and when you read this a year or so ago at the time of the submission of the counter memorial, you knew it was wrong then, correct?
Yes,
But you elected not to say anything at the time.
the opportunity is right now.
And do you know, are you aware of the fact that both your counsel and Belmont's counsel have waived cross-examination of Mr. Dorfner?
I'm aware of it.
Now, that statement, so you deny that there was a refusal of them to allow you to come directly into Roseman, correct?
Correct.
You did not come directly into Roseman, though, did you, sir? That wasn't the route you came in.
Eventually, we came into Rosmin.
Right, but you came in through the back door, didn't you, sir?
Yes.
And the back door was Rima Moran.
Well, they may not have liked it, but we came in.
Right, and you didn't disclose to them after they had refused to let you in the front door that you had a plan to go in the back door, did you?
That's not correct, Mr. Alexander. I protest against it. There was a meeting between Dorfner and Tyson and myself, my brother Reinhard, and Rima Moran, and I made clear after I had personally advanced $200,000 to Mr. Chori so that he would not be diluted in his interest. This money didn't come from EuroGas or any company. It came from me personally because there was such a short time in order to save his interest in the deal. The Germans wanted to push him out. And I got a phone call at that time from the managing director of Thyssen Schachtbau, Mr. Löhr, and he was furious that I had helped Chori to stay in the deal. And then in the end, they said, okay, fine, we have no choice, and they accepted us.
But you went through the back door of Rima Moran because you couldn't go in the front door, isn't that right?
I protest against it. That was not a backdoor because I explained to Thyssen Schachtbau exactly the way we want to do it. We want to finance Rima Moran, want to help them to maintain the shareholding in Rosmin, because a very important item came up, the feasibility study, which cost 2 to 3 million Deutschmarks, and Rima Moran would never have been possible to finance this feasibility study. And I explained this to Thyssen Schachtbau, and they finally accepted it.
Mr. Robal, once again, I have to ask you, is there a reason you didn't provide that information earlier in your witness statement, any of that?
Well, I didn't consider it important. You bring up the questions now, and my memory gets back, and I'm telling you this. At that time, when I filed my witness statement, I didn't consider answers to these questions important.
And is there a reason you didn't put into the record any documentary support for what you've just alleged?
No, there's no reason.
But the fact is, you did come in through Rima Moran by acquiring a majority position in that company,
With the approval of both shareholders.
for which there's no evidence in this record, is there, Mr. Robal?
I haven't checked that. I don't think it's important.
Whether they approved or not?
They approved it. I'm on a oath.
But wouldn't you think, Mr. Robal, in something as significant as this, there'd be one document that would substantiate?
I have to object now. I should have objected since the beginning when the representation was made that this issue that is central to this case on what point and on whose perspective. Irrespective of that, the witness has answered on many occasions, I didn't think that this was important. I didn't think that this was important. So I think at one stage, we have to stop this. The testimony is that I didn't think it was important. And when it is central to the case, you have to mention on what point and from whose perspective to the witness.
Members of the tribunal, I might ask for clarification. Is that an objection on behalf of Belmont or EuroGas?
On behalf Relates to the merits as well. The case you're putting is important to you post facto defenses on the merits and not central to this case, according to us. And I responded many times, it was not important. I didn't think it was important.
I don't think there's a valid objection here, but we've understood your point, the questions that you repeatedly asked, and it's not necessary to
Ask any more.
ask the same questions again and again.
All right, understood. Thank you, Mr. Chairman.
If I may make a suggestion, Mr. Chairman, all these questions, all these answers can be put towards Dr. Roslosnik. He was there too.
The the lawyer has the right to ask you the questions he chooses to ask you, and maybe he will ask also these questions to some other witness.
So it is your testimony before the tribunal, Mr. Robal, that you received no indication from either Dorfner or Tyson that they believed you were an inappropriate partner.
I didn't say that. I said they were not happy, or at least Tyson was not happy, but they finally accepted us.
And how did they express to you the fact that they were not happy?
Because they had a certain business plan. They wanted to push Rima Moran out of Rosmin. Because Rima Moran was financially very weak, had no money, and they didn't like very much that somebody like Deus Ex Machina comes out of the blue and helps them, and they stay in the project.
So if I'm understanding correctly, your testimony today, for the first time, is that you helped Mr. Chore stay in the project.
Of course.
And at the time you provided that help to him, how long had you been working with him?
I did not work with him at all. I had met him through Dr. Terscher from the Ministry of Environment of the Slovak Republic, and he had introduced him to myself.
And why did you believe it was appropriate to help Mr. Chore stay in the project?
Because Mr. Terscher had asked me to do so.
And that was the only factor?
Well, I had said earlier that I had met Dr. Terscher already in the early 90s, together with Bill Agiagos, when we were looking for some Slovak mining properties. And at that time, and I'm referring to that, by the way, in my witness statement, we were also getting acquainted with the Gemerska Poloma situation. But at that time, we felt it wasn't ripe, it wasn't interesting enough. And when I met again with Dr. Terscher 6 years later, 5 to 6 years later, he asked me if I wouldn't reconsider, and he told me that in the meantime a lot of work has been done, and that's when I reconsidered.
How long after you entered Rosman through Rima Moran did Dorfner and Tyson tell you that they were leaving the project?
I don't know the exact time, but it was not very long afterwards, maybe 2-3 years.
In fact, it was the next year, wasn't it? You came in 1998, and they announced they were leaving in 1999.
Well, if you tell me this and the figure is correct, then I believe it is correct. All I remember is it was a short time afterwards.
All right. What's your understanding of why they decided to leave?
Mr. Alexander, I just gave you the answer. ThyssenSchachtbau had substantial financial problems, and they were cutting down their worldwide operations, and that's the reason why they left the project. Financial problems.
You knew that they were exploring financing, didn't you?
Pardon me?
You knew that they were exploring financing when you entered the project, didn't you?
Are you referring to the DEG?
Yes.
Yeah.
Or Deutsche Bank?
Deutsche Bank I'm not aware of. DEG. I'm aware of DEG because I visited DEG myself.
How long after Dorfner and Tyson announced that they were pulling out of the project did DEG stay in?
DEG never gave an approval to any financing, even as long as Dorfner and Tyson stayed in the project.
And that was notwithstanding what you've described as the very favorable report from Hansa Geomin?
A report is only favorable if you get the money. It may be the most favorable report in the world. If you don't get the money, doesn't help you very much.
What's your understanding of why DEG pulled out?
I don't know. I cannot tell you. They may have changed total investment philosophy. Had nothing to do with the Gemaska polymer project.
So with Dorfner and Tyson and DEG no longer involved, what was your plan for capital development for 25 million euros?
To joint venture with a renowned, respected company in the industrial minerals sector.
And how many of such companies did you have more than preliminary discussions with?
We had more than preliminary discussions.
With how many such
I
companies?
personally had discussions with Talc de Luzenac, the Rio Tinto subsidiary, and with Mondo Minerals. Both companies had their chief geologists and mining guys on the property several times. I remember that Luzenac was there at least twice, Mondo Minerals 3-4 times.
Did you ever get to exchanging any draft of preliminary agreements?
I did.
And are any of those in the record?
I submitted them to our lawyers. I don't know if they put them on record.
Did you have any discussions with Luzenac about their possible participation?
Yes,
Did you get to any preliminary stages with them?
yes. They were very interested.
Do you know why they lost interest?
They didn't lose interest. They probably were also disenchanted because of Mr. Chori.
They were probably disenchanted because of Chore. Did they ever say that to you?
That's my assumption.
In fact, and I say this with respect, Mr. Robo, but you assume that everything that went wrong with that project was due to Chore, don't you?
And believe me, I am correct. Believe me, I am correct.
And that's why you brought tried to instigate a criminal prosecution of him?
No, I did not do that.
You didn't initiate a criminal investigation with Slovakian authorities? You deny that?
I deny that. I never did this.
But despite that relationship with Mr. Chore, you never took steps to replace him as the contractor until he walked off the job for non-payment, did you, sir?
Mr. Alexander, I don't know why you always come back to the same question. Mr. Chori pretty soon was gone because he got into a fight with Rosmin, with Dr. Roslosnik, and the problem then didn't occur anymore. Although I strongly believe that Mr. Chori is was behind all these dubious, in my opinion, corrupt practices which followed later on.
So when he suspended work on the project in 2001, and Roseman gave notice of suspension of work. What steps did Roseman take at that time to get a new contractor in there?
I cannot tell you because I wasn't involved in the day-to-day operations, but I'm sure Dr. Roslosnik and probably also Mr. Agiagos can give you more background there.
Mr. Robal, you had a substantial investment in this project. Is it your testimony before this tribunal that when the contractor walks off and notice of suspension of work is given, you don't have any personal knowledge of what happened after that to get it back on track? Is that what you're saying?
No, that's not what I said. I said I have personal knowledge, but I cannot give you detailed information what has happened on a day-to-day basis.
Did you have any conversation with Roslosnik to the effect of, you better get going and get this back on track and get another contractor in there because Chore's been nothing but a mess anyway, let's go?
That's exactly what I told him.
And when did you learn that there was virtually no progress on that front?
That's in his presentation as
Well,
well.
I'll rephrase the question. When was the first time that Roseman put out another request for bids to get the project back on track? It wasn't until 2004, was it?
Well, I remember that Rosmin had made several applications to the mining office, lower mining office, informed them that there is a delay, and according to my knowledge, Rosmin got an extension, and in the meantime, we sorted out the problems with Rima Moran.
And that took 3 years.
I cannot answer that question. It takes several months to get the answers back from the mining office. But I wasn't involved in the day-to-day operations. And regardless if this is a major or was a major enterprise for us, I was not involved in the day-to-day operations. But I'm sure there are other witnesses here which can give satisfactory answers. I can only say that the relationship between Mr. Chori and Rosmin and myself deteriorated to a point because of certain acts and deeds which we didn't find appropriate. And I give you one example. When we purchased our interest in Rima Moran, Mr. Chori insisted on cash payment of a large amount of money, 1.2, 1.3 million Deutschmarks. And he wanted to have that money in Liechtenstein. And we definitely don't deal in Liechtenstein. So that was the condition he had, and we wanted to get control of Rima Moran in order to get going with this project. So we arranged for him through an affiliated company to get 1.3 million Deutschmarks. Now, before you ask me, Mr. Alexander, we made a note in the SEC financial statements about this. And that's how badly the relationship between Mr. Chori and us had deteriorated.
Well, that, according to your allegation, which as you know he's denied, that actually came at the very outset of the relationship, didn't it, sir?
No. That money was, he demanded that money, if I'm not mistaken, in 1998. And he got the money.
That's the date when you came into the project by purchasing your interest in Rima Moran, isn't it?
It may be.
The fact is that according to your story of this payment that you say concerned you so much, it didn't concern you enough not to get into business with Mr. Chori, did it? Under your version of events, which is, you know, he's denied. It didn't stop you from getting into business with him, did it?
He may deny it as much as he wants. The document is on file here. It shows his signature that he received I don't have the footnotes in here, $1.3 million in cash, and it was confirmed by two bank employees. So what else do you want to hear?
Well, I would like to have heard some of this when you read his witness statement where he denied that that was his signature, but you chose not to respond on that either. My point, Mr. Robol, is simply this. You thought this payment was improper, according to your story.
No, I did not say that. I protest. I really protest here. We put it even in the SEC files. I said, okay, we will arrange this for you. If you want to have that money in Liechtenstein, fine, we do this. But we didn't hide this payment. We showed this payment openly in our financial statements and made a note in our SEC files.
So I'm a little confused, Mr. Robol. You haven't said there was anything improper about this payment. That's what you're saying now?
Absolutely.
Mr. Chore had no illegitimate purpose in asking for it. Is that what you're suggesting?
I'm suggesting that he did not want the payment to be wired to him by ordinary way through bank wire. He wanted to have out of the payment for the interest in Rima Muran a cash payment, in cash, Mr. Alexander, in a bag, to be paid in Liechtenstein. We did this, but we reported it in our financial statements, and we reported that he got this money through an affiliated company in Liechtenstein.
So taking, for purposes of discussion, your version of events, which Mr. Chore has
It's the
denied,
truth, Ms. Alexander, it's the truth.
you felt perfectly comfortable going forward with him, did you not, on your version of events?
At that time, although I was shocked that he was making demands like that.
And were you shocked enough to bring it to the attention of either Dorfner or Tyson?
I think that they were out already.
You think what?
It was none of their business, it was our business.
So the answer is you didn't bring it to their attention?
No.
You weren't that shocked?
I was shocked, but why do I have to tell the world about a relationship which I'm having with Rima Muran? We dealt with it, and later on, the experience showed that my attitude was correct, and that I shouldn't have trusted Mr. Chore. In addition to that, he recorded as purchase price on his financial statements this transaction only being 1 million Slovak crowns, which is the equivalent of some $30,000. So he didn't say that he got 1.2 million Deutschmarks plus additional consideration. No, he said the total purchase price for the shares was $33,000. Wouldn't you be shocked if some of your client would that too? I was shocked.
If one of my clients came to me with a bag of cash, yeah, I'd be shocked.
Okay, so we talk the same language.
I think it might be a big red flag, and I would wonder whether I had a responsibility to alert people.
We did.
But not Tyson and Dorfner on your version of events.
We
Your partners in the
alerted the
transaction.
anti-corruption police in the Slovak Republic.
How many years later?
4 or 5 years later.
I'll move on from this, Mr. Robel. Might I ask if this is a convenient time for a break? We've been at it a while, hour and 20 minutes.
Yes, okay, we make a break. 15 minutes. Mr. Robel, as I think you are aware, you must not talk with anyone about this case. So, Mr. Alexander, you can proceed.
Thank you, Mr. Chairman. Mr. Robel, I want to go back to the share purchase agreement you signed with Belmont in March of 2001. Do you recall that?
Yes.
And that was the agreement to which we referred earlier, where you promised to bring sufficient capital to bring the project to commercial production within 1 year from the date of execution. You recall that?
Correct.
How did you book that transaction, sir?
Pardon me?
How did you book the transaction in your financial statements?
I don't know. I don't remember.
Well, let's come at it a different way. You're familiar with the principles of consolidation?
Yes.
If you control a subsidiary, you are permitted to consolidate its operations into your own financial statements.
Correct.
And prior to the share purchase agreement, had you ever done that with respect to Roseman?
No.
But after the acquisition, you started doing that, isn't that right?
I'm not sure. I think we recorded it on an equity basis, cost basis.
And if you had recorded it on an equity basis, you wouldn't have been allowed to consolidate, correct?
You ask me questions right now on accounting which I can't answer to you.
All right. Well, let's take a look, if we could, please, at, what's it, tab 11, which is Exhibit R73. Can you tell us what that is, sir?
This looks like the 10K for EuroGas Inc. for fiscal year ended December 31st, 2003.
And you, of course, as a sophisticated businessman, appreciate the importance of filing accurate financial statements as part of your annual Form 10K.
Correct.
You understand there are potentially very serious penalties if you do not.
I understand.
Take a look, if you would, please, at page 4 of that exhibit. Just below the bar that begins with the sentence, "The purchase of the interest in Rosman SRO." Do you see that?
Yes.
Was recorded at $3,843,560. And you can, of course, read the rest of the sentence, but I want to ask you first a question about that. In fact, that reports that you booked the transaction with Roseman as a purchase, the transaction with Belmont as a purchase of the shares in Roseman.
That's the narrative. But it was meant Belmont.
Well.
No, I'm sorry. I'm
No,
sorry.
I'm not suggesting there's anything wrong with your description.
I was just saying, I'm sorry.
I'm just saying, you report there that the purchase had been recorded on the company's books at a value of $3,843,000.
Yes.
And then you go on to explain the basis for that amount. No goodwill was recognized in the purchase transaction. And then you say, and this is the sentence that I really want to focus on, "The operations of Roseman have been included in the consolidated results of operations from its purchase." Do you see that?
No.
It's in the last sentence of that paragraph.
Okay.
That was a true statement, wasn't it?
It was.
And in fact, the only way you could possibly have lawfully consolidated the results of Roseman in your financial statements as a result of that purchase was if you had acquired control of it.
Well, it's a matter of interpretation. First of all, I didn't do this. Our CFO did this, and I assumed it's correct.
Did you review the financial statements before they were filed?
Yeah, but I'm not an expert in accounting.
In fact, what was your title with EuroGas at the time?
At that time, I think I was CEO and director, president and CEO.
And the CEO of a public company has a particular responsibility to verify the accuracy of its financial statements. Wouldn't you agree?
I agree.
And that's why you took it so seriously and ensured its accuracy before you signed it.
To me, these numbers were correct.
Now, you said in the next paragraph down, actually, I'm going to skip down 2. You reported here in the second paragraph, second sentence of the third paragraph in that section. So I'm 2 paragraphs below where we were. Mine construction, which began in August 2000, is scheduled for completion in 2004, at which time talc production is scheduled to commence.
Excuse me, Ms. Alexander. Which one are you referring to?
I'm referring to, do you see the bar across the page there?
Yep.
All right, count down 3 paragraphs. Second sentence, mine construction, which began in August 2000.
I read this.
Now, of course, the project was not completed by 2004, was it?
It couldn't be because it was taken away from us.
Well, actually, you hadn't even begun further works on the shaft to the deposit at that point, had you?
That's not correct. We have done extensive work on the mine.
I'm talking about from the period of 2001, when Mr. Chore walked off the project, you gave notice of discontinuance of operations. After that point in time, there had been no further work on the opening works to reach the deposit, had there, sir?
The reason for that were those delays caused by waiting for the final approval from the mining officers, mining department officers. On or about, and I guess this took 1 or 2 years until Dr. Roslosnik sorted it out. As I said, I wasn't involved, I can only report. On or about May 31st, 2004, the Lower Mining Office issued an approval to continue the works and granted a date until mid-November 2016 to complete these works. And as far as I remember, Rosmin started to resume the operations in Gemerska Polymer in summer 2004, including negotiations to get a new operator, which resulted in fall 2004 in the appointment of Siderit as operator.
So is the answer to my question yes, and that's the explanation for it?
What was your question again?
It is true, isn't it, Mr. Robal, that from the time Mr. Chore walked off the job in 2001 and you gave notice of suspension of works, that from that time until the reassignment of the excavation area, there had been no progress on opening the access to the deposit in the western area? Yes or no?
Well, they couldn't, because we only got approval on May 31st, 2004 to continue the works. And immediately Rosmin resumed operations to start with the opening of the mine.
And when did you first apply to resume operations?
I don't know.
Yeah.
I understand that Dr. Roslosnik is coming. He can answer all these questions.
Now, let me ask you if I could please to turn to page 29 of the 10K report before you. Do you see underneath Mr. Blankenstein's signature, do you see the statement, due to lack of funding at this point, in particular the inability to pay our auditors, we are forced to issue our annual statement with only information that is prepared by the EuroGas management. Do you see that?
I see it.
Do you recall what the auditor's fees were at that point?
I don't. But they were substantial.
So, even though the auditors weren't involved in this work, the company reported that the purchase of the interest in Rosman was recorded at 3.8 million, is that right?
Correct.
And thereafter made the decision, without the blessing of the auditors, to consolidate its operations.
At a cost basis, correct.
And the date of this 10K, can you see that up there next to Mr. Blankenstein's signature?
May 15, 2004.
Right. And do you recall when the EuroGas was put into bankruptcy?
On or about that time.
And EuroGas initially entered an appearance in the bankruptcy proceedings, did it not?
Possible. I don't recall.
Don't recall.
The lawyers handled this.
Right. I was wondering if you might have followed that proceeding closely like you have this one.
No, I was living in Germany at that time, and I left it up to Mr. Blankenstein to take care of these matters, because he was living in Utah and was running the day-to-day operations of the company.
Do you recall that EuroGas opposed the filing of the involuntary petition for bankruptcy and entered an appearance and retained counsel and participated in the proceedings? Do you recall that?
I do.
All right. And do you recall there came a point in time when you were ordered by the United States Bankruptcy Court to provide schedules of assets and liabilities? Do you recall that?
I do.
And you and two other people in the company were the subject of that order. Do you recall that?
I don't recall two other people in the company.
The only one you can remember is yourself?
And Blankenstein.
Okay. And you did not file schedules of assets, did you, sir?
Yes, as I said before, I was in Germany, and I left it with our chief financial officer, Hank Blankenstein, who resided in Salt Lake City, to take care of this. And
But you knew that you were the personal subject of the order, right?
I do, although I was never served on that order. I've never received the order.
But you had actual notice that the court had ordered you to do that.
From Mr. Blankenstein, yes.
And if a schedule of assets had been filed in compliance with the court's order, would you agree with me, Mr. Robal, that it would have been reasonable to include the interest in Roseman and this potential claim, given the fact that you were actually consolidating the operations of Roseman into the EuroGas financial statements?
Yes,
I would have to say an objection. It's calling for areas that are outside of his knowledge.
He's answered, I'll live with the answer. And when did you first learn that Mr. Blankenstein had not filed schedules of assets?
I did not learn, because I had told Mr. Blankenstein, we had one problem at that time. The previous management had left a mess behind in the company, and most of the files were gone or were not available. So I had told Mr. Blankenstein to talk to the previous trustee, Trustee Joel Marker, and sort this problem out, even if we don't have any files. And he talked to Mr. Marker. I know that.
You saw during opening statements yesterday testimony on the screen offered by Mr. Blankenstein in the bankruptcy proceedings, did you not?
Correct?
When did you learn that he'd given that testimony?
I don't recall. There were so many depositions done by Trustee Smith. I cannot tell you.
Now, in fact, prior to the bankruptcy, EuroGas, what we've called EuroGas 1, had been dissolved under Utah law, and you knew that.
Yes.
And is it true, Mr. Robal, that when it dissolved, you were its CEO?
No.
What was your position at the time?
Well, it may be that I was CEO, but the fact that it was dissolved was the mistake of the previous management, which unfortunately forgot to make a $15 payment to the registry in Salt Lake City. And I found out only later on, actually, when Mr. Blankenstein told me. I think it was on or about 2005 when he told me that.
And did you investigate whether it would be possible to reinstate at that time? You were within a 2-year period.
Yeah, but the previous management had, in my opinion, they had already let this lapse a long time earlier.
You didn't find out from counsel or otherwise what steps you could take at that point?
I did. After I found out, immediately I instructed Mr. Blankenstein to do the appropriate steps to see legal advice and find out how to remedy this situation.
So it's your testimony that you weren't aware for 2 years that your company had been dissolved?
That's correct.
Now, if you had filed a schedule which included the consolidated results of Roseman, the trustee would have been in a position to assess what it wanted to do. No dispute about that, is there?
I think he was in a position.
But you base, well, let's not get into the legal quibble. After you had come out of bankruptcy, well, first of all, did you ever alert the bankruptcy court or the trustee to the fact that the company had been dissolved?
Not me personally.
And did you ever take any steps to alert the investing public that the company that was being publicly traded on the securities markets no longer existed?
I don't recall. But I can tell you what I told Mr. Blankenstein. I said
I'm not asking for that.
All right.
Did you ever take any steps to file on the Austrian or commercial, Austrian or German commercial register what had happened with respect to EuroGas?
There's no necessity to do that.
Did you ever alert the German stock exchange where the shares were traded that the company no longer existed?
No, I didn't know that. I didn't, as I told you, I only learned about it 2005, 2006.
And So after you come through the bankruptcy process, you took steps to create a new EuroGas 2.
I informed Mr. Blankenstein to take steps to do this immediately.
Right. I actually misspoke, Mr. Robal. It was actually while the bankruptcy was pending. And given the fact that the bankruptcy was still pending, you still took no steps to alert the court to the status of the company.
Not me personally.
Did you advise your lawyers to do that?
I advised Mr. Blankenstein.
Did you ever follow up with him to see if he ever did anything further on it?
No, we did this over the phone. I just told him to solve this problem and get legal advice, get to a lawyer and get this done.
And when you got the court's order directing you to file schedules of assets, did you ever follow up with him to see whether he had filed those schedules?
Yes.
What did he say?
He said that he had approached our previous auditor, Doug Hawks of Hanson Barnett, and had asked him to provide data to the trustee.
Did he tell you that he'd ever filed schedules of assets and liabilities?
Blankenstein?
Yeah.
Well, we didn't have any files. We didn't have any documents to file the list of these assets. So that's why I told him, see our auditor, previous auditor, Doug Hawks, and seek advice and ask him to get in touch directly with the trustee, Joel Marker, which he did.
And because you say you didn't have any files, I take it the answer to my question is no, he never told you that schedules of assets and liabilities had been filed.
Well, I learned later on that they were not filed.
And did you ever follow up with Blankenstein, to whom you delegated the responsibility, to ensure that assets and schedules of assets and liabilities had been filed? The fact is, you didn't do that, did you, Mr. Robal? You never
I
followed
did,
up.
of course I did. And he told me that he had spoken with both, with the trustee and also with Doug Hawks, our previous auditor, and Doug Hawks told him that he had been, or that he has been asked for deposition by the trustee, and Doug Hawks provided the entire files, which we unfortunately didn't have anymore, to trustee Marker.
And did Mr. Blankenstein tell you that he testified under oath that EuroGas didn't own anything in the talc mine?
Well, I think it was part of the financial statements, and I saw that in Trustee Smith's statement, deposition statement.
Let me see if I can ask the question again. Did Mr. Blankenstein tell you that he testified under oath that EuroGas didn't own any interest in the talc mine?
Yes,
He told you that?
yes.
Sir, that's a mischaracterization of what Mr. Frankenstein said before the bankruptcy court.
I don't agree. I'll
Bring,
live with the
bring,
answer.
put the document in front of him. It is clear, it's in my tab 76. I'll do that if you don't do that.
I don't have any-
would not let you mischaracterize.
I asked him first, as you'll recall,
No,
Mr.
no, I
Garage.
think you should show the
I'm
document.
happy to do that. What do we?
Tab 76 of our opening bundle, it's R0116, public bankruptcy proceedings. And at page 71, we have the answers and questions, they are clear.
I asked him, as the tribunal will recall, whether he'd seen the testimony on the screen yesterday. And I'm happy to put this to him now. Of course. Of course.
Thank you.
have it?
You say 77?
76.
76, the very last one.
76, it's on our opening bundle, it's R0106.
Oh, 106.
106.
Sorry.
Do you have page 69 in front of you, Mr. Robo?
I do.
Question was asked, now, isn't it true that EuroGas does not even own this talc project? And the answer was, that's correct.
I apologize, allow the witness to read. It's page 69 to 71, 72, allow him to read. It's 69 and then it's 71, the question. Thank you, sir. Now you're buying this Rosman talc deposit from Belmont, A, correct, and then it goes on. Page 71.
Okay?
Mr. Robo, did Mr. Blankenstein get into detail on the subject matter of his testimony?
No,
Did he talk to you at all about his testimony?
he did.
Did he tell you that he had said that EuroGas does not even own this talc project?
He did.
Now I'd like to ask you, Mr. Robal, to turn to tab 14 in your witness binder, which is R0209. One more question, Mr. Robal. Did you discuss with Mr. Can't remember his name, Blankenstein, whether he'd ever made any disclosure of the claim relating to the reassignment of the excavation area? Had he ever disclosed that to anybody?
I don't recall.
Now, you have before you R0209. Do you recognize that document, Mr. Robal?
I do.
Did you initiate proceedings that resulted in an investigation of Mr. Chore by criminal authorities?
No.
Do you know who did?
Yes.
Who did?
Mr. Danicek,
And who is he?
former Managing Director of Rosmin.
And did you discuss that with him before he initiated those proceedings?
Yes,
You understood he was going to do it?
correct,
You were supportive of it?
correct.
Now, turning to page 4, if I might ask you to do that. Do you see the second paragraph there? This is in response to a question. Well, let's see. Let's see. I'm focusing on the question, the answer there. I'm an executive of EuroGas GmbH. Do you see that?
Yes,
Which is a subsidiary of American company EuroGas, Inc., in which I am the chairman of the board of directors and supervisory board. Roseman is a company in which EuroGas GmbH has a 33% share. Do you see that? And the American company EuroGas, Inc. has a 57% share, i.e. 90% together. Do you see that?
correct,
Did you make that statement to criminal authorities while you were under oath?
I did.
And you took seriously the responsibility to tell the truth that day, didn't you, sir?
Well, I was of the opinion that this statement was correct at that time.
Yeah. Let's turn to tab 15, if we may now. R0265.
Zero 0265?
Yes, that's the exhibit referenced. Do you recognize this document?
I do,
You've seen this before.
yes,
And it's dated February 16, 2012. Do you see that?
yes,
It purports to be a EuroGas press release. Do you recall preparing this?
I did not prepare it, but I recall it.
All right. You signed it,
I did,
or at least it went out under your name and title, I should say. You authorized its release.
that's correct.
And because of the requirements of applicable securities law, I would be safe to assume that as the chairman, you take very seriously your responsibility to report matters accurately when you're issuing a press release on behalf of a company.
Correct,
You, of course, are sensitive to the fact that under U.S. securities law, there are significant penalties for intentionally making false statements in a press release. You know that, don't you?
I know that.
All right. And in this document, under the heading marked EuroGas AG is issuing the following clarification in this respect. And I'm interested in the third bullet in particular. EuroGas is a holder of 57% of business shares of company Roseman SRO. EuroGas acquired said business shares contractually in March 2000. Do you see that?
I do.
And did you make that statement with knowledge of the facts that surrounded the statement?
I didn't make the statement, but I signed it.
All right.
It was done prepared by our Swiss auditors, Swiss Swiss lawyers.
And I assume you also, and just in the interest of time, you also authorized the next paragraph. EuroGas expressly confirmed the rightful title of EuroGas GmbH to 57% of business shares of company Rosman SRO.
Yes,
And the reason you were willing to issue this press release is because you had taken the consideration received from Belmont in the share purchase agreement, which was the shares in Roseman, and you had assigned that on, sold that on to EuroGas GmbH.
No,
It's not true?
I approved this and signed it as our lawyers prepared it, and I had no doubt that this statement would be wrong in any circumstance.
So you thought it was true at the time you signed it?
At the time I signed it, yes.
And your lawyers had reviewed it? Is that correct?
They prepared the text. I didn't.
All right.
I didn't.
And your accountants had also been involved in this discussion and review, is that right?
That's correct.
And then the final paragraph, EuroGas AG thereby directly and indirectly holds 90% of Slovak mining company Roseman SRO. Does all your prior testimony about the procedures that were involved in apply to this paragraph as well?
That's correct.
Mr. Robal, you are aware, of course, that Belmont and EuroGas filed a request for arbitration which initiated these proceedings.
Originally, it was EuroGas Inc. which filed the request for arbitration.
Yes. And did you review that document before it was submitted to initiate these proceedings?
I did.
And in that document, you described the claimant as EuroGas, a company having been incorporated in 1985. Is that right?
Correct.
And at the time, you knew that that's not who the claimant was in this proceeding, didn't you, sir?
Give me your question, please.
At the time you reviewed and authorized that filing to be made, you knew that EuroGas, the 1985 company, was not the claimant in this proceeding?
No.
You didn't know that?
No. What I wanted to say is I just relied on the judgment of our previous lawyers in Prague, which had suggested this, and I just assumed that this fact is correct.
You assumed that the claimant, you thought that the claimant was the 1985 company. That's what you assumed.
Yes.
So it was your intention in submitting and initiating these proceedings for that claimant, for the 1985 company to be the claimant.
The difference between the 1985 company and the 2005 company, the EuroGas 2, the legal consequences out of this came only to my judgment later, several years later. At that time, I was of the opinion it's the 1985 company which is making the claim.
That was your intention, to make it on behalf of the 1985 company.
Yes.
That's pretty good. Yeah, I got it. Now, there came a point in time after the bankruptcy that there was a document related to merger that was drawn up. Do you recall that?
Yes, I do.
And it purported to merge the 1985 company and the new company, what we'll call the 2005 company, or EuroGas 2. You're aware of that?
I am.
Did you personally participate in the preparation of that step?
No.
Who handled that?
I actually got a phone call from Mr. Blankenstein at that time, and he said he found a lawyer in Utah who suggested how to handle this merger, and which is our current corporate solicitor, Mr. Michael Coombs. And then I said, well, go ahead and get this done.
And so you authorized that step to be taken?
Yes.
Now, did you ever file articles of merger?
No.
Did you ever advise the Austrian or German commercial registers, notify those registers, make appropriate filings there to notify the merger?
No, the lawyers for our companies are doing this.
But to your knowledge, it hasn't been done yet, has it?
Sorry, which hasn't been done.
Giving notice of the merger?
They assume that there is a merger.
Did you ever make any filing with the SEC that you had merged the prior company into a new company by the same name?
I guess so, yes.
You guess so?
Yeah.
Where is that?
I don't have it here. I'm sure that our lawyer can answer that.
So if it's not in any SEC filing that's in this record, do you have any reason to believe it's somewhere else? If it exists, you think it's in here, in this record?
I don't know. What I know is that our Utah-based solicitor had discussions with the SEC about this document, and they didn't raise any objections to it. So I assume that everything is fine.
And have you ever seen any documents to substantiate that any such discussion occurred?
If my lawyer tells me that everything is fine, I assume that everything is correct, and I don't have to look at additional
Well,
documents.
but your lawyer, being a good lawyer, would presumably have some written record of the conversation, or a letter memorializing it, or an email to you, anything like that?
He does,
He's given you that?
yeah. Not email, but he told me that he had done so.
He
yeah.
told you? Yes,
Discussed
I
with the SEC in 2011, and there was no problem.
Members of the tribunal, I would beg your indulgence and respectfully request that we receive that document. Given the late disclosure of its existence, we would respectfully ask that it be provided to us.
Which document exactly?
The document that purports to memorialize approval by the SEC of the merger he's describing.
Okay, we note your requests.
Mr. Chairman, I'm close to finishing, but I wonder if I might beg your indulgence in a short 5-minute break to just focus and be done. Thank you very much. Mr. Chairman, there's one other document I would like to respectfully request before you announce, and I'm not sure you're ready to yet, but I wanted to.
Well, first, we have made a decision on your first request.
Is it related?
Yes. It's about 3 lines above in the transcript.
Okay, make it.
It's the point where he, let's see, where is it, Steve?
152107.
It's 1521.
07.
07. The question, did you ever make any filing with the SEC that you had merged the prior company into a new company by the same name? Answer, I guess so, yes. Where is that? I don't have it here. I'd also like to respectfully request that that document be provided.
That's what we had understood.
No, the second one was came a couple of lines later, and in that context, he said that his lawyer had some memorandum or email, it was a little fuzzy, but I'd like to request that that be produced as well,
On the same issue.
on the same issue, that memorialized the fact that this conversation has supposedly occurred.
I think we can give the same answer. Okay. So the answer is, we don't make an order, but we tell claimants that if they find these documents and they find it useful to file them, it's authorized.
Thank you. We will check with the corporate attorney for EuroGas to see if he actually still has those.
Thank you, Mr. Chairman.
Mr. President, although everybody trusts the judgment of the tribunal, would appreciate if this were to reoccur, to have a chance to speak before the tribunal deliberates on such issues. But we're happy with your order.
I would just note one other point. One of the documents we asked for was the SEC filing to which he referred, so it wouldn't be a question of whether he still has the documents. It would be a public document. We've been unable to find it, but since Mr. Robo represented it exists, we would appreciate being provided it.
Well, I agree with you. If it exists, it would be a public record, and so I don't see a need for us to have to go try to find that one.
Okay. Considering the nature of our answer, I don't think it would have been of any use for you to say anything.
No, that's why we said we're very happy with it was just in anticipation of the future, potential ones that may recur.
Okay. So,
Thank you, Mr. Chairman. That concludes my cross-examination.
thank you. Now we're going to have the examination of, sorry, redirect.
Unfortunately, some redirect questions, but first I would like, yes.
I have to leave the room? Yeah.
No, you stay. You have to answer more questions.
Oh, okay.
Sorry, give you false hope.
Mr. Robel, other than the bankruptcy proceeding which was instituted against the 1985 company, or has been referred to here sometimes as EuroGas 1, have you ever been involved in a bankruptcy case under the United States Bankruptcy Code?
No.
So I take it you're not familiar with the forms that are filed by a company that is placed into bankruptcy?
That's correct.
Have you ever even seen the type of forms that a company in bankruptcy is required to file?
No.
In response to questions from counsel for the respondent, and specifically, you don't need to look at it, I don't think, their tab 15 in their bundle, which is R265, and was a press release relating to an announcement made in, I don't know if it was Switzerland or Germany, but it had to, oh, she's gotten it out for you there. In it, you indicated about direct and indirect ownership, and what I want to ask you to do is to explain your understanding of direct and indirect ownership of corporations.
Direct ownership is if the company holds a direct interest in the other company. Indirect ownership is if the company holds an interest in that company through an intermediary company.
With regard to the 1985 company, and I'm going to focus your answers here, and I want you to focus your answers here as of May 18th, 2004, which is the date on which the involuntary bankruptcy was filed against the 1985 company. As of that date, was the interest of the 1985 company in Rosman a direct interest or an indirect interest?
It was an indirect interest
And why do you say that?
because it was held through the Austrian company, private company, EuroGas GmbH.
So is it accurate to say that as of May 18th, 2004, the 1985 company owned a direct interest in EuroGas GmbH,
That's correct,
but did not own a direct interest in Rosman?
yes, correct.
With regard to the actual mining interest, the permits, the leases, the mining equipment, with regard to this talc project, as of May 18th, 2004, which entity owned those assets?
Rosmin,
Did the 1985 company own any direct interest in any of the assets located in the Slovak Republic on May 18th, 2004?
the talc assets?
Right.
No,
Okay.
did not.
I'd like for you to take a look, and I believe the bundle is there, in the claimant's opening bundle. It's going to be tab number 76, Exhibit R 106. You would just turn it so that you see the date on, it'd be the next page. It's not going to be there. This is Mr. Blankenstein's testimony before the bankruptcy court that was referred to by the respondent's counsel in questioning you here a few minutes ago. And if you look at the pages marked 69 of the transcript up in the top page, it's probably the second page in this particular one, where Mr. Blankenstein was asked the question, isn't it true that EuroGas does not even own this talc project? And he answered, that's correct. Do you see that answer there?
Yes,
Okay. And as it relates to owning a direct interest in the talc project, would you agree with Mr. Blankenstein?
I would agree, yes, it's correct.
If you would look up at the very top of the page, you will see a couple of dates, one being August the 17th, 2004. At the very top of the page. Do you see the dates, August 17th, 2004 and August 18th, 2004?
Yes, I do.
Is it your understanding that those would reflect the first one, the date on which the hearing occurred?
I assume so.
You assume so.
I don't remember exactly.
If we were to compare that date to the date on which the Slovak Republic expropriated the rights in either late December 2004 or January 2005, would you agree that that expropriation occurred after this testimony?
It did.
And certainly you would agree that the expropriation occurred after the bankruptcy case was filed.
That's correct.
I want to direct your attention to July of 2008, I believe is the month, certainly the year, when the 1985 company and the 2005 company signed a joint resolution. Do you recall that? Joint resolution?
You talk about the F joint resolution
Yes,
merger?
yes.
Yes.
Okay. At that point in time of the signatures on that joint resolution, what was your position with the 2005 company?
I presume director and CEO.
Do you recall what your position at the time of the signing of the resolution was with the 1985 company?
I assume the same.
Do you believe you're in a position to testify to the intent of both of those parties on the purpose of that document?
Yes, I believe so.
Would you please tell the tribunal what was the purpose from the viewpoint of both of the parties to that document? What was the purpose of the document?
The purpose was to find a continuation of the 1985 company, which, as we found out at that time, was dissolved, and to have a transaction done in the best interest of the shareholders of EuroGas, Inc., assuming all liabilities of the 1985 company and all assets of the 1985 company, whatever the assets are. I might add that EuroGas, the 1985 company, was a very successful company. When I helped to
And I'm going to stop you there. You've probably gone beyond the bounds of my question. So is it fair to say then that the intent of the parties was to effect a transfer of the 1985 company's assets to the 2005 company?
that was the intent.
And was it the intent of the parties to have the 2005 company assume the liabilities of the 1985 company?
Correct, that's what I said.
What was the intent of the parties to the joint resolution with regard to the shareholders of the 1985 company?
To take over the original shareholders.
So that they would be shareholders of the 2005 company?
Yes.
Did the 1985 company cease operations following the execution of the joint resolution?
Well, that's a legal question because
If you don't know the answer, that's
I don't know
fine.
the,
Okay.
I don't know the answer. The legal answer, I don't know.
Mr. Robal, could you turn to our binder, opening bundle? The first one. At tab 18, which is R0169. You were asked questions by counsel for respondent on financial issues relating to Roseman and Rima Morin. And this is a letter during the peak of the dispute, I would say, July 25th, 2001, from Rosman to Rima Morin, and you are copied in that letter. And the second page of that letter suggests that invoices for certain months were not paid. If you look at the second page, where you're CC'd, and that assuming invoices were sent, there would still be a overpayment because of the advance payment, and therefore there is a conclusion. We therefore cannot recognize and accept the suspension of works due to non-funding works by Roseman. The question to you is, do you recall receiving any letters in response from Rima Morin challenging the tables and the financial situation as summarized in this letter? And if you don't remember, say you don't.
Let me make myself familiar with it. No, I don't remember that.
Then, if you move to tab 22, it's R0130. It's a settlement agreement, March 26, 2002. Were you involved in that negotiation?
Directly and indirectly.
Okay.
Indirectly through one of our employees, Jürgen Preuss.
Okay. How about the handover certificate protocol, which is October 2002, which should be at tab 19?
Could you help me, please?
R0131.
Okay?
It's the handover protocol. Were you involved in that?
No.
Suggestion was made to you by respondent's counsel that not much had happened from from October, let's say 2002, to May 2004, when Roseman obtained authorization to resume mining activities until the end of 2006. Do you recall what happened during that period? You mentioned a court decision.
Can you repeat your question once more?
What happened between October, what was Roseman doing between October 2002 and May 2004?
They were negotiating with the mining office
Yes.
to get an extension, which they got of the work permit or concession, whatever you may call it. And it ended in the issuance of a new, we called it may be legally wrong to call it, a new concession dated May
I
30.
understand, Mr. Robal. My question was, why did it take so long between, do you recall, between October 2002 and May 2004 for you to obtain such an authorization?
Well, I personally was not involved, so I
Okay.
can't tell.
Could you turn to tab 25, which is C226? Were you involved in the court litigation? Namely, the request had been denied first by the mining authority, and the main mining office reversed that decision, 2003, May 15, 2003. If you don't remember, say you don't remember, Mr. Robal, and we move on.
I don't remember.
Okay.
I know of it, but I don't remember this specific
Okay,
document.
and we're going to hand you further documents, whether you recall. Who was running the operations at that period?
Of Rosmin,
Yes,
Dr. Roslosnik,
okay,
and Bill Agiagos.
okay. Were you involved in these processes, C239, C240, C233, namely the different permits that were secured, applied for in the meantime? Permit for drifting of exploratory winds, TALC. The following one, for a temporary civil structure or to approval to exclude the area from the forestry area.
No, I was not involved.
Okay, let's take the last one maybe, C233, and you turn the page to the sticker. It says the request was supported by the below documents. Were you involved in the preparation or the instruction for the preparation of an expert opinion and the different other documents?
Oh, you need to be a little slower. So C233, which page?
C233 should be the second page. Were you involved in the preparation, the instruction for the preparation of an expert opinion?
No, not at all.
Okay. Now, I move to another issue, which is the statement used by counsel for respondent, issue that is central to this case. Do you have knowledge or involvement in which areas are central to the case from a perspective of international law, for example, or causation? Or do you rely on others for that?
Could you tell me, ask me again?
Are you a lawyer?
No,
Okay.
of course not.
Now, I ask you for Siderit. I come to Siderit, the period around the time just prior when Rosamond's rights were revoked. Were there any outstanding bills from Siderit?
No,
Did the government of Slovakia, any agency, raise any concerns to you in relation to Rosamond's financial capacity?
not to my knowledge.
Now, on the issue of the bankruptcy, could you turn to tab 70 of the opening bundle? 76.
Excuse me.
Here, it's Mr., how do I pronounce his name? Backenstein. Blankenstein. Before the R0106, R0106, it's the same document, R0106. In the bankruptcy proceedings, in response to Trustee Smith, who I understand initiated, caused the opening of the bankruptcy. If you turn to page 71, was asked to your representative, now you're buying this Rosamond talc deposit from Belmont? The answer was correct. Then the question, and you did that by issuing 12 million shares of newly issued EuroGas stock? Answer was no. There was subsequently going to need to be issued 12 million shares, but they haven't been issued. They would prefer the cash at this point. And now you owe another 12 million if they're willing to take it, or they want 1.6 million Canadian dollars, correct? Do you have the ability to pay that? Right now, no. Then is it true that your testimony was that you had 4 to 6 weeks to pay that, or the talc deposit would be lost? There is the answer, very distinct possibility, yes. Question is that, was this statement reported to you at the time?
Yes,
Do you think that's a wrong statement, that your rights would be lost?
no, I think it was correct. If we didn't pay, we would have lost anything, or we wouldn't have gained anything under the agreement.
Do you think today, you, Belmont, EuroGas 1, EuroGas 2, EuroGas 5, 6, anyone that you are aware of has any claim to the ownership of the 50% shares of my client, Belmont?
Honestly, no.
How about the money you paid?
That will be a situation which the lawyers will have to sort out. I myself am not the guy who initiates lawsuits. On the other hand, it is very difficult to initiate a lawsuit because Belmont could argue that we were in default of the payments, etc., so they could come with damage lawsuit. It's a very, very difficult question right now.
Finally, you were asked questions on your statement in criminal, in the context of criminal proceedings. It's R0209. The document you were shown missed, I think, a few pages, so we are providing it to you again. It should be the last one in the recent bundle that was distributed, in the hard copies that were distributed in that folder. Yes. In these documents, you have the permits that I went through, correct? Then you have that statement made. You said the share is still registered in favor of Belmont, but it will be registered in favor of EuroGas within a short time. Is that a true statement, Mr. Robal?
Which page is that?
Page 5. Where's it, is that it?
You had 5 missing. I had 5, I gave.
Some of the copies do not have page 5.
No, it's our,
No, it's
Yeah,
not
but
a full
it's
copy.
missing in the copy.
We have 4 and 6.
Yeah, it's the same document.
so it's a relevant page you're missing.
Exactly.
Okay, good.
That's from their bundle.
But that's for their bundle. That's why we distributed it to you.
No, yeah, for sure.
We handed to you,
The one with the red flag.
there was a red flag on
Yeah,
it.
we see.
Okay, there you go.
I received it.
And you have it as well?
No, that's mine. So,
Do you want to have it?
which,
It's the
under
one
which
we
tab?
just,
209.
The one, yeah, with the red flag.
Second.
good. That's why we redistributed it, because there was this missing. You say the shares of Belmont would be registered in favor of EuroGas Inc. within a short time. Is that scientifically exact? Is it, what is this?
At that time, I was of the opinion that EuroGas Inc. could make the payments which were due under the SPA, which didn't happen. So it was wishful thinking, let me put it this way,
I appreciate, Mr. Roba, I did not want to suggest that to you.
on my part, I mean.
Yeah, let me, and what's the rest? Due to my opinion, corrupt illegal revocation of the license to mine, our company was unable to pay with bankruptcy, and we had to pay $130 million. Is that a correct statement, Mr. Robal?
I believe so, yes.
You had to pay, doesn't it suggest that you paid?
No, we did not pay.
Okay, but the way it's
We did not
drafted,
pay,
it could
but
suggest.
we have an obligation to pay 113 million.
Okay, thank you.
Thank you, Mr. Raubal. Your examination is completed. We thank you for your cooperation. And I think we must have a break before we hear Mr. Roslostnik because of technical issues.
Thank
So
you,
how long?
Mr. Chairman.
2 minutes, 5 minutes.
5 minutes.